bar next door. But I'm doing that because he very, very seldomly catches me lying to him. Because I never typically lie to him. Like, I don't ever have a reason to lie to him.
What?
Or anyone, really. And then he's like, now I just think I sound like an idiot because he knows he received this card and he sees me at your old address. And I even was stupid enough to say, like, well, that's Erika's old address, but I'm just, like, at the bar next door. So maybe tomorrow I'll just fess up and say, like, yeah, and then I went there eventually. But he sees my location. Like, he's requested my location, like, a long time ago. And then when I shared mine with you last time, is like...
Oh, shit. I'm, like, 46 minutes into recording. I mean, 46 seconds, I mean. My bad. I'm sorry. Good story. Cool story.
No, I just, like, maybe I'll complain tomorrow.
Well, all of the live world knows that you lied now.
And I did not know. I had no idea that you sent them that card. Like, I don't know what I thought you were
waiting for. What do you mean?
I know I had no idea what I thought you were waiting for, but I'm like, I had no idea that you sent it already.
Oh my god. No, I was just gonna get you to sign it so I could just use it next year.
Well, no, just in general, like when I was here with you, like waiting for you last year, like people thought I was nuts. Like sitting here waiting.
Look, I want to do this. I didn't ask you.
Either my parents think I'm nuts or he just caught me lying.
Private land use controls the law of servitudes. Land use arrangements arising out of private agreements. Tendency to create reciprocal burdens and benefits binding on successors. Somebody's ready for bed. Introduction, classifying servitudes. Doctrinal labels are traditional and I guess the traditional doctrinal labels included. It's interesting. I feel like I just didn't continue in that direction in this outline. So actually, no. I'll say traditionally it looks like we're talking about easements and covenants and then all servitudes. What comes next? No, nothing else comes next. So in this little short sort of introductory, we're going to talk about easements and covenants, but probably we'll go into everything in a little bit more depth. So under easements, there's promissory agreements against a successor to land, including the dominant easement and the servient tenement. The dominant tenement is holds an interest in the land of another. The servient tenement is the land that's burdened by the easement, for example, over which the easement runs. And it can affect any type of an estate, a term of years, a fee simple, and it is irrevocable during the easement life, which distinguishes it from a license, which is revocable. Easements must be in writing to satisfy the statute of frauds, and oral easement is only affected by estoppel. And then there are implied easements. Within the covenant section, covenants are enforceable by law. Real covenants run with the land. Covenants that are enforceable in equity are referred to as equitable servitudes. So this is where kind of the doctrinal, traditional labels might come in. I think they're all called real covenant or covenants now, but real covenants technically are covenants enforceable by law, but equitable servitudes are covenants enforceable in equity. So historically, this evolved to provide better protection. They were formerly known as restrictive covenants. And today, the Restatement Third has converged easements, real covenants, and equitable servitudes subject to a single set of principles. And that would be in the Restatement Third of property servitudes, which is the American Law Institute adopted in 2000. And all servitudes, these overlap, starting with easement. Example 1, A is given the right to enter upon B's land for ingress and egress. And then right-of-way is an example. And erecting a sign or a billboard is an example. And placing utility pole, wires, or pipes is an example. Affirmative easements give the holder the right to enter on the other land of profit. For example, A is given the right to enter upon B's land and remove something of value. Negative easements, real covenants, or equitable servitudes, if that is the remedy sought as an equity. Examples are A is given the right to enforce a restriction on the use of B's land. And real covenants or equitable servitudes are the distinction between the two depends on the remedy sought. Example A is given the right to require B to perform some act on B's land, and and that's all that's written there. The second example is A is given a right to require B to pay money for the upkeep of specified facilities. Easements. Historical background and some terminology. Profits apprendre. Need for rights of way. Enclosure, farming, cattle raise, and industrial revolution were discussed in the needs for rights of way. But affirmative easements, like for instance, the right to hang laundry over a line or use water. Rights of way is the right to get to the other side. And negative easements did not evolve until later. England created 4 and then stopped classifying negative easements. One was to block the neighbor's window and view. The second was to interfere with air flowing to one's land in a defined channel. The third, removing the support of one's building or by excavating or removing a support wall. And lastly, interfering with the flow of water like an artificial stream. Negative easements were difficult to discover but applicable by actual constructive knowledge and can arise by prescription in traditional England to unduly restricted buyer. The court didn't believe servient owner would grant to another a right to not do something on the land. And in the U.S., negative easements allowed but not by prescription. Yeah, so English courts were like, why would a serving owner grant to another a right to not do something on their land? So they were like, this needs to be invalidated in our court system, and it was. But what did we do in the U.S.? We allowed it, but we didn't allow it by prescription, perhaps by grant, promise, or covenant, convolution, and thus a right created by promise should be treated as a right created by grant. It requires notice. It requires some economic efficiency because market would function to remove obsolete easements. So generally this means the easements are paid for. An example would be the unobstructed view of San Francisco Bay over the neighbor's house. In the case Peterson versus Friedman, 1958, or solar panel interference. Restatement third, section 1.2, negative easements treated as restrictive covenants. Comment H, conservation and other novel easements, scenic, and this is just a list of them that appeared in the book. Conservation and other novel easements, scenic and historic, asset preservation, open space, land trust, owner gives land to public body or private charitable organizations, tax deductible as a charitable gift, uniform conservation easement act by negative easement not suitable, UCEA purposes to enable durable restrictions and affirmative obligations to be attached, right? To So under UCEA, purpose is to enable durable restrictions and affirmative obligations to be attached. I have a couple things about that. I have to protect natural resources and restrictions are kept immune from certain common law impediments which may be otherwise raised, protects undeveloped land against various threats, its wild character, like adverse possession. Conservation easements are perpetual, transferable, can be in gross. And no temporal limitations. Opposition proposed application of a charitable trust law doctrine of Cyprus to allow modification of conservation easement. That might be like in perpetuity. Proposed liability rule, conservation easement, proposed capping tax deduction incentive. Easement appurtenant. So those are all the crazy details about easements that have like special purposes. Negative easements, restrictive covenants, but mainly the conservation ones. Land trusts, conservation easements, for example, and the Uniform Probably Conservation Easement Act. So moving on to the other type, easement appurtenant. Easement that benefits the holder in the use of the holder's land. Benefited land is the dominant tenement. Easement runs with the dominant tenement, gives the right to whomever owns the parcel. If the question is of which kind. Easement appurtenant requires both a dominant tenement estate can transfer to successor unless personal, and a servient tenement, which is the burden estate. They need to be appurtenant, which means like adjacent to one another. Default, if there is a doubt if an easement is appurtenant or in gross, courts will interpret it as an appurtenant. Majority rule is the holder of an appurtenant easement may not use it in connection with non-dominant land, and that any such is subject to an injunction. And third restatement of property servitude, section 4.11, 2000, comment B, in exceptional situations, however, courts occasionally permit a landowner to extend use of an appurtenant easement to property adjacent to the dominant estate by awarding to servient owner damages rather than an injunction for the unauthorized use, while using the court's power to select a remedy appropriate to circumstances, i.e., negotiate a consensual solution. Generalty equity, the dominant tenement owner costs are much higher than burden on servient estate owner. Normal abnormal development to be reflected in law. The holder of an easement or profit is entitled to use the servient estate in a manner that is reasonably necessary for the convenient enjoyment of the servitude. The manner, frequency, and intensity of the use may change over time to take advantage of developments in technology and to accommodate normal development of the dominant estate or enterprise benefited by the servitude. Unless authorized by the terms of the servitude, the holder is not entitled to cause unreasonable damage to the servient estate or interfere unreasonably with its enjoyment. The nuisance rule to determine when the development is abnormal. And the term for this is to surcharge the estate. Easements permit entrance and exit of people and vehicles above ground and underground utilities such as electrical lines and sewer pipes. Location of easements, once fixed by parties, cannot be changed without permission of servient tenement. This was softened by the restatement third of property. If a change reasonable and do not reasonably lessen utility of easement, increases the burdens on the owner or frustrate the purpose of the easement. Easement growth. Benefits holder personally, not in connection with use of any specific parcel of property. Gives right to some person without regard to ownership of land, meaning they don't need to be like a neighbor. Divisibility, transferability of easement and gross for commercial purposes. Miller versus Lutheran Conference and Camp Association. This was a Pennsylvania case. Easement and gross for commercial purposes can be transferable and divisible if expressly intended by the parties. The creation of easements, which is kind of the most important section, is part performance, estoppel, creation by implication, created by prescription, scope less broad than easement, created by grant, implication, and necessity. So, by prescription, you have a lot of the same elements of adverse possession. So it has to be adverse, open, and notorious, no attempt at concealment, underground pipe if discoverable on inspection, for example, connection above ground, under a claim of right, which is adverse, a hostile component without the owner's express permission. Objective or the subjective test, there's a jurisdictional split on that. And continuous, claim of right, periodic acts that give notice to owner that easement is being claimed. Uninterrupted is an alternate definition. Jurisdictions are split on continuous. The majority sees the owner of a servient easement must effectively stop use. The minority observes the lost grant theory. I don't have any note cards, and it says here to see the note card. Lastly, exclusive is not dependent on use by anyone else. Adverse possession involves a statute of limitations running on the right to bring an action to recover possession of land and extinguish the remedy of previous owner leaving the adverse possession in an indefeasible position. Easements involve the use and not the possession of the land. Doctrine of prescription. Rights can be acquired simply by passage of time. Usually requires exclusivity, but use unless it's a public easement. And here I've got more about the last grant theory. 20 years of use gives rise to a presumption that a grant of an easement was made in the past and lost. That's the lost grant theory. And it requires a showing by the claimant that there was no permission, the owner acquiesced. Majority jurisdictions reject the lost grant theory, and the minority of jurisdictions see it as long as it's enclosed and rests such for neighbors who acquiesce. Public prescriptive easements obtained by long continuous use by the public under a claim of right. Put landowner on notice is one of the first elements by the kind or extent of use that an adverse right is being claimed by the public, not individuals. Theory of implied dedication. Landowner evidences intent to dedicate and state accepts by maintaining land. Express dedication generally grants and usually involve gratuitous transfers in land to a government body or public at large. And doctrine of customary rights. Memory of man runneth not to the contrary. The public trust doctrine comes from Matthews versus Bayhead case. Reservation. Provision in a deed creating some new servitude and gross which did not exist before as an independent interest. Exception. Provisio in a deed that excludes from the grant some pre-existing servitude on the land. I'm wondering if that is a separate subject. Okay. And then you have implied easement, another separate subject. Two types of implied easements, and both must result from lot split. One is an easement implied by pre-existing use, and the other is an easement by necessity. For pre-existing use, there was a pre-existing use on the property when it was all owned by the same person. It must be which requires that the lots are appurtenant. It must be an appurtenant easement. They must arise from the lot split, must have been existing use on lot before the split, and must be necessary, and the servient tenant must have notice. Easement by necessity. There's a jurisdictional split on the extent of the necessity. There's reasonable and strict. Reasonable is the majority position that reasonable necessity found if the grantor conveys the dominant estate. The more strict view of necessity applied in the minority of jurisdictions, including California, holds that it's strict necessity if the grantor keeps the dominant estate. Navigable waters count as egress, and expense to build egress is of no importance. EBN, easement by necessity, will terminate if no longer necessary. For example, access to the public road becomes available. Regrant theory and license. We're still going to be talking about easements for a little bit of a while here. Wow. This really goes on a long time. Okay. So 8 more pages, let's say. Let's read the regrant theory. Easement doesn't reserve interest in grantor, but the grantee regrants interest to the grantor. This would require a signature from both parties by statute of fraud, but the grantee had, by accepting the deed, made it her own and adopted these in signature of the grantor. That's a sentence. Easement can be perpetual in duration for life or term of years. Note, licensees. License is an oral or written permission given by an occupant of land allowing the licensee to do something that would otherwise be a trespass. Revocable easements, not revocable. Not revocable when coupled with an interest incidental to ownership of chattel or licenser's land. Bears resemblance of easements by necessity and is treated as an easement. Example, Shepard versus Purvine. The plaintiff were negligent in failing to assist their friends draft a formal transfer of rights. As such, the oral license becomes a legal, unrevocable easement. Oral easements. I think this is of an oral nature because the first case is Henry versus Dalton, a statement of legislative intent for oral agreements not put in writing, not to encumber land unless in equity. Is this an equitable servitude then? Is the question I have in the margin. So that case probably had to do with what is it? And we probably only saw it just as a means of defining these things because, like I said, there were some traditional labels that made them very alike things go by different terms. I also wrote estoppel ? Because we go on in this section of easements, just generally titled easements. Normally, the change in position that triggers application of the rules stated in this subsection is an easement in improvements either to the servient estate or to other land of the investor. Case Van Sant versus Roysters. Protection that existing use will continue after transfer by easement by estoppel and implied grant reservation. Implied grant favors a grantee and requires reasonable necessity under the new rules. Reservation favors the grantor. It requires strict necessity under the old rules. And intent proof when oral grant for easement or of easement is, and I wrote in parentheses, implied. Intent proof is the severance of title to land initially undivided. There's an apparent existing and continuing use of one parcel at the time of the severance, and a reasonable necessity for the use at the time of the severance. I'm pointing down here to servitudes implied from a prior existing use versus by necessity is reasonably necessary to enjoyment of the parcel, for example, access, and also unattainable without substantial expenditure of money or labor. So that all is supposed to fall under the definition of what proof goes to intent. Why are we talking about intent? I think I'm talking about because as it relates to oral grants of an easement, like implied easements. So for intent, we have to be talking about divided lot. We have to be talking about apparent existing and continuing uses of the parcel since it was severed from a combined lot, and then reasonably necessary, but also kind of strictly necessary at the same time. So quasi easements endure indefinitely is one of the things I've written here. Graveyard rights, I've written going to, I don't know why it's pointing to strict necessity under the old rules, but maybe that's something that applies to. I'm just going to keep moving on to the quasi easements endure indefinitely, easement by necessity. So let's get to a new section. It's a little less all over the place. Navigable waters is a legitimate ingress and egress, which would apply for a landlocked property, apply to a landlocked property. So under the strict necessity formulation, reasonable necessity, seems to be something that we talked about before rather than in this section. And FYI, an easement by necessity, Massachusetts is the one that says the purchaser of landlocked property suffers from his own folly. There is no easement by necessity unless it's like a strict definition of necessity. Termination of easement. Easement owner may release an easement. Statute of frauds normally requires a writing. Expiration at the end of a stated period. Stated conditions. Easement created by necessity ends when the necessity ends. Easement terminated when a dominant and servient tenements joined in ownership, for example, merger or unity of title. And then there is estoppel. Estoppel ends ownership of dominant tenement owner who tells the servient tenant owner that he'll stop using the easement, and the servant tenement owner changes their position in reliance to his detriment. So that's how easements can be terminated by estoppel. Another is abandonment, but non-use doesn't extinguish the easement. Abandonment occurs when non-use plus a written release or an act demonstrating the abandonment, including unequivocal oral release coupled with a failure to maintain. See the case Marvin M. Brandt, Revocable Trust vs. U.S. of 2014. There's judicial estoppel. Well, judicial estoppel has nothing to do with easements, but it's just good to know. If you take a position in a case and win, it's not fair to take the opposite position and win the opposite argument if it were to come up. In this particular case, it had to do with railroads, like abandoned land surrounding railroads. There's like an actual act of how to deal with it. And so I guess one of these companies or the landowner might have been like, it was taken by prescription in one case, and then opposite case they were like, it was taken by eminent domain or something. And then like if they're opposite positions and that in order just being used just to win two different cases, it would be barred by judicial estoppel. Whatever, that's what that terminology means. It's not so much applicable to easements as it is just an interesting term to know. A better example would will be helpful. Probably happen a lot in like a criminal case and a civil case.
That's what.
Yeah, like just thinking about a tort of like false imprisonment, maybe. Like if you were to say, if you were to accuse someone that you don't want to be criminally in trouble for false imprisonment, if you were to say one thing so they get out of it in a criminal trial, but then in a civil trial, when you're trying to recover from that person, right? You don't want to go to prison because you want to recover from them. So you avoid them in prison by saying one thing at their trial, but then in a civil action, you're saying the opposite thing. That's what judicial estoppel is. It's if you take a position in a case and win, it's not fair to take the opposite position to win the opposite argument, basically. That's maybe a better example. Change conditions doctrine may amount to a termination of real covenants, equitable servitudes on foreclosure, condemnation action, judicial proceedings to condemn an easement includes payment of damages. Government needs no easement by way of eminent domain. Assignment of easements appurtenant. Transferability of easements in gross right not permitted if that I think I crossed this out. I'm not really sure. It says transferability of easements in gross right only permitted if that was the original intent because it can burden servient tenement more than appurtenant. And if you remember, I think from that Pennsylvania case we were talking about that it is only commercial easements in gross are the only kinds of easements in gross that are divisible and transferable. So that's why you have to set only if that was the original intent. So that's like a really limited use case. Restriction on assignability of easements in gross. When the railroad companies and utilities couldn't be transferred, the law changed the restatement thirds of property servitude, section 4.11, blah, blah, blah. And here comes a Marvin M. Brandt revocable trust case again. The railroad release of easement P, usually intended to be personal. Exclusive and divisible. I just keep reading on through this outline, but we're talking about literally very different things under this transferability section. One of which is exclusive versus divisible. Approach today is an easement is divisible unless expressly contrary by intent of the parties. Easement owner has the sole right to engage in activity if it can be shown no excess burden on servient tenement. Scope of easement remedies. Case Brown versus Voss. Case notes. Easements are a non-possessory interest in the land of another as opposed to real covenants and equitable servitudes. Real covenants and equitable servitudes came about because there is a shortcoming in contracts that prevents provisions such as prohibiting uses that would give rise to tort liability for nuisance from being enforced against them because contract provisions don't run with the land. All right, so that's your Brown versus Voss case on the scope of easement remedies. Kind of defines what easements are, non-possessory interest in the land of another, as opposed to real covenants and equitable servitudes. and why they exist, which is that contracts are deficient to produce the effect. Now, the majority rule is that the holder of an appurtenant easement may not use it in connection with non-dominant land, and that any such is subject to an injunction. The restatement third of property servitudes, comment B, states in exceptional situations, however, courts occasionally permit a landowner to extend use of an appurtenant easement to property adjacent to the dominant estate by awarding the servient owner damages rather than an injunction for the unauthorized use, using the court's power to select a remedy appropriate in the circumstances. So, I've written in the margin here, current remedy law. Generalty equity, the dominant tenement owner costs all must be higher than the burden on the servient estate owner. That's the definition of generalty equity. Don't know why it's here. I mean, we're talking about remedies, okay? So what I just said from the restatement third of property servitudes was that a dominant estate. No. In exceptional situations, courts occasionally permit a landowner to extend the use of an appurtenant easement to property adjacent to the dominant tenement. I feel like it should say servient tenement for that to really truly make sense. But I digress. Technological development to be reflected in law. What do I mean by that? What I mean is if at the time of the grant of the easement, only like horse-drawn motor vehicles was intended, and now like gas-powered motor vehicles exist, and since the easement is like over a dirt road, by using, like, say for instance, huge trucks on it, you could be surcharging the estate that did not intend for that type of a thing at the time that it was the easement was granted. So I guess that hasn't made its way into the restatement yet. That's perhaps what I'm trying to say. Easements permit entrance and exit of people and vehicles above ground and underground utilities such as electrical lines and sewer pipes. Location of easement, once fixed by the parties, cannot be changed without the permission of the servient tenement, softened by the restatement third of property. If a change is reasonable and do not reasonably lessen the utility of the easement, they increase the burden of the owner and frustrate the purpose of the easement. Prescriptive easement scope less broad than one created by grant implication and necessity. So all of that I've read before. Termination of easements is next. Easement owner may release an easement. Statute of fraud usually requires a writing. There is an expiration at the end of the stated period in some easements that are granted, and so that would be like I feel like it's condition is how that's sometimes referred. Easements created by necessity, when the necessity ends, that can terminate. Merger can terminate when the dominant and servient estates are under the same ownership. It has to be the same interest, meaning that you can't, even though the dominant and servient tenants could be the same owner, if the owner owns one parcel in fee and the other parcel is just a life estate, it technically is not a merger. Estoppel ends ownership if the dominant tenement informs the servient tenement owner that he'll stop using the easement, and the servient tenement owner changes their position in reliance to his detriment. Abandonment, and we go to Marvin and Brandt again. A lot of this is duplicative, I recall. In the case notes for this is deeding a right-of-way can be a fee simple or easement, but usually an easement unless using a statutory deed, i.e. quitclaim deed, exclusive versus shared use. Rails to Trails Act is what came up in that case. Takings, President versus ICC, VT rail banking statute resulted in physical occupation and money damages available to the landowner after abandonment, not by injunction. Can foreclose term easement. Courts may modify or even terminate real covenants and equitable servitudes on the basis of change condition doctrine. A court may modify or if modification is not feasible or is ineffective, a court may terminate a servitude if post-creation change of circumstances has made it practically impossible to accomplish the purpose for which the servitude was created. Obsolete easement on the basis of what is in effect a frustration of purpose doctrine and overburdenment to a degree can terminate an easement. Then you have negative easement. Right to stop dominant owner, to stop use of servient owner from doing something in the servient land. There were 4 types enumerated before England stopped classifying them. I actually read them already. It's like blocking the view, interfering with airflow, removing support, subsistence, interfering with water flow. In the US, I talked about how negative easements are allowed, but not by prescription. So reemphasizing grant. Requiring notice requires some economic efficiency because market, so basically payment element. Market would function to remove absolute easements, and then I go to the restatement, which treats negative easements as restrictive covenants. Conservation and other novel easements. I went through all that. Starting with the scenic and historic preservation, open space, land trust, uniform conservation easement act created because negative easement is not suitable for longevity. Grantee to grantor purpose to enable durable restrictions and affirmative obligations to be attached. Without being interfered with by like adverse possession. Conservation easements are perpetual, transferable, can be gross, temporal, no temporal limitations to them, and environmental covenants impose activities such as the Cleanup Act and use restrictions on contaminated land and permit the contaminated land to be developed within limits imposed by restrictions. Now, preservation easements, agreements with private historic preservation associations. Sham easements are conservation easements without great public value. For example, tax deduction exceeds value to the public. And Uniform Environmental Covenants Act of 2003, purpose to remediate and develop parcels previously contaminated by industrial use to eliminate potential obstacles to enforcement of environmental covenants. Under common law doctrine, such as concern horizontal privity, adverse possession. Facade preservation easement prevents alterations of registered historical places. And lastly, the primary residence easement, vacation home, and drive-by owner not legislated, are they enforceable? So that's the end of easements, bringing us to covenants in the next recording.